Please be seated. The sitting is open. The court meets this afternoon to continue the remainder of the first round of the oral argument of Ukraine, and I now give the floor to Ms. Cheek to complete her statement. You have the floor, madam.
Thank you. I will now turn to Russia's violations of the ICSFT. Amid a stream of terrorist acts in Ukraine, amid the flood of Russian funds crossing the border to finance these acts, Ukraine sought cooperation from Russia. Under the ICSFT, Russia could have chosen a lawful path: good faith cooperation to prevent, investigate, and punish terrorism financing. Russia instead chose an unlawful path: delay, inaction, willful blindness, and outright falsehoods, defying its cooperation obligations under ICSFT Articles 8, 9, 10, 12, and 18. These are the violations of the ICSFT from which Ukrainians have suffered. The states parties to the ICSFT noted in the Convention's preamble that, quote, "The number and seriousness of acts of international terrorism depend on the financing that terrorists may obtain." Shelling civilians in peaceful cities far from conflict, detonating bombs at peace rallies, shooting down civilian aircraft. These are very serious acts, and they depended on financing by Russian persons. Yet Ukraine's repeated requests for cooperation from the Russian Federation to help cut off the financing of these terrorist acts fell on deaf ears. Ukrainians suffered through one terrorist act after another from early 2014 to early 2015. In response, Ukraine sent dozens of requests to the Russian Federation, seeking cooperation to prevent and suppress the financing of these acts. Ukraine provided names, bank accounts, websites, information on weapons supply convoys. Ukraine waited for responses and continually asked for cooperation. Ukraine's border guard service made multiple requests for a joint meeting with Russian officials. Russia chose to stay silent. Eventually, the Russian side responded. But those responses only confirmed that Russia had no interest in genuine cooperation to suppress and prevent the financing of terrorism. I should note that Russia's obligations under the ICSFT are not only triggered by requests for assistance. Russia had a duty to be proactive. Yet when it was obliged to act, Russia did nothing. Let me now briefly summarize Russia's specific violations of its cooperation obligations under the ICSFT. For every example that I give here today, there are many more reflected in Ukraine's written pleadings. ICSFT Article 8 requires states parties to take appropriate measures to identify, detect, freeze, and seize funds used to finance terrorism. As I just mentioned, this obligation is not triggered by a request. Russia has an obligation to be proactive. In 2014 and 2015, it was common knowledge that the DPR and LPR were committing terrorist acts in Ukraine. In their push to win political concessions, they engaged in a campaign of intimidation, attacking civilians and killing and seriously injuring many. In Russia, people were openly funding these groups. Russia therefore had a duty to identify the funds being used for this purpose and to detect them if they could not easily be identified. If there was reasonable suspicion certain funds were being used to finance terrorism, Russia had a duty to freeze them. But Russia did nothing. Russia defends its failure to act by asserting that Ukraine has not conclusively proven various alleged mental elements of terrorism financing offenses. That is false, but it's also irrelevant to Ukraine's claim under Article 8. Cooperation does not mean demanding conclusive proof, while at the same time closing your eyes to existing evidence. At a minimum, where there was a reasonable suspicion of terrorism financing, Russia had an obligation to temporarily freeze the funds and promptly investigate. Instead, Russia did nothing. Russia also ignored Ukraine's specific requests. To take just one example, on the 29th of August 2014, Ukraine notified Russia of specific individuals and specific bank card numbers being used to finance terrorism in Ukraine. Most of the relevant accounts were at Sberbank, a state-owned bank. Had Russia wanted to cooperate, it could have taken swift action. But Russia did not respond for almost a year. When it did, all Russia said was, quote, work to identify the persons mentioned in the note, as well as the details of their bank accounts, is being processed at the current time. This non-response speaks for itself, but let me add two observations. First, when it comes to freezing assets used in terrorism financing, speed is essential. Freezing is a temporary emergency measure. Seizing comes later, after more due process. If reasonable suspicions are not acted on, funds may be used to finance terrorism, and then it's too late. Waiting a year to even begin processing bank account details is not good faith cooperation or compliance with Article 8 of the Convention. Second, at the time Russia responded to Ukraine, Russia mentioned none of its current arguments that are before this court. Russia did not claim that the individual funders lack knowledge under Article 2. They did not say that there was nothing that gave rise to a reasonable suspicion. Russia could not say that, because for a year it showed no interest in investigating, no interest in determining the culpability of these individuals at all. Again, that is not good faith cooperation that the ICSFT requires. Russia displayed the same indifference under Articles 9 and 10 of the ICSFT. Under Article 9, if Russia received information that a person committed a terrorism financing offense or was alleged to have committed a terrorism financing offense, Russia was obligated to investigate the facts. Under Article 10, Russia was obligated to extradite offenders or to refer them for prosecution, treating the case in the same manner as any other offense of a grave nature. Again, Russia did none of those things. Just a few examples are more than enough to illustrate Russia's violations of Articles 9 and 10 of the ICSFT. In August 2014, Ukraine sent Russia a request for assistance. Ukraine described the terrorist acts being committed by the DPR and LPR, including that they were aimed at intimidating the population. Ukraine also provided Russia with information about specific persons and legal entities suspected of terrorism financing. This included Putin loyalist Konstantin Molofeev, a major shareholder in Rostelecom, one of Russia's largest state-controlled monopolies. Again, Russia did not respond for nearly a year. When it did respond on the 31st of July, 2015, all Russia could say was, quote, it was not possible to identify the location of Mr. Molofeev. While Russian authorities apparently did not check his office in Moscow, where American journalists were able to find Mr. Malofeev to interview him in October 2014. It's an understatement to say that Russia did not investigate the information that Ukraine had provided. Russia did nothing. In the same request from August 2014, Ukraine alerted Russia to terrorism financing by Alexander Zhukovsky, who publicly admitted fundraising for the DPR. In November 2014, Ukraine informed Russia of additional terrorism financing offenses committed by Mr. Zhukovsky. When Russia finally responded on 31 July 2015, it said that Mr. Zhukovsky, quote, does not exist in the Russian Federation. Russia apparently did not click the link supplied by Ukraine, which would have taken them to Mr. Zhukovsky's social media page, where he boasted of hosting a fundraiser for the DPR. Russia also apparently did not notice that Mr. Zhukovsky gave interviews to the Russian media, where he was described as a St. Petersburg-based activist. These are surprising activities for someone who does not exist in the Russian Federation. Once again, Russia did nothing. As a final example, Ukraine asked Russia to investigate the, quote, Coordination Center for Assistance to Novorossiya, describing it as one of the centers of financing and provision of assistance to the operations of terrorist organizations in the territory of Ukraine. Once again, Russia ignored this request for a year. When Russia finally responded, it informed Ukraine that the center, quote, does not have electronic accounts, and that military items are not acquired by the group. In this case, Russia appears not to have consulted the center's own website, which has links to electronic bank accounts accepting donations and elsewhere boasts of providing non-humanitarian aid and sending all kinds of useful items to the militia. Again, Russia did nothing. Russia's responses to Ukraine's requests for cooperation are indefensible. That explains why Russia has not even tried to defend them before this court. Instead, Russia argues that in order to even request cooperation, terrorism financing offenses, quote, must be conclusively proven with the requisite specific intent. But that's backwards. Article 9 requires a state to investigate when a terrorism financing offense is alleged. Investigation is what produces the proof. Since Russia's failed to investigate under Article 9, it's perhaps not surprising that it also could not comply with its obligation to prosecute or extradite under Article 10. Ukraine has provided evidence showing the commission of terrorism financing offenses by Russian officials and other Russian persons. At a minimum, the established facts warranted serious attention by Russian prosecutors. Article 10 required Russian authorities to take their decision in the same manner as in the case of any other offense of a grave nature. Instead, Russia did nothing. In short, Russia had no interest in suppressing the financing of terrorism in Ukraine. Russia never investigated allegations of terrorism financing in a timely manner, if at all. Russia never fulfilled its obligations to extradite or prosecute in the same manner it would have for other serious grave crimes. Through this refusal of genuine cooperation, Russia breached its obligations under Articles 9 and 10 of the ICSFT. Russia also failed to offer the greatest measure of assistance to Ukraine in connection with its criminal investigations of terrorism financing, as required by ICSFT Article 12. Ukraine sent many such requests for assistance. Instead of engaging with those requests, Russia did the opposite. Ukraine made at least 12 mutual legal assistance requests related to terrorism financing investigations. For half of them, Russia offered a bare invocation of national security and sovereignty. Russia did not explain how terrorism financing investigations implicated its national security or sovereignty. Indeed, it's difficult to see how providing assistance with a terrorism financing investigation could undermine national security or sovereignty. In Djibouti v. France, this court found that such an unexplained denial of assistance violated a mutual legal assistance treaty. It also violates Article 12 of the ICSFT. In other instances, Russia refused assistance based on supposed, quote, procedural formalities. For example, Russia denied assistance because Ukraine had not supplied the place of birth of potential witnesses. That is not affording the greatest measure of assistance under ICSFT Article 12. Even where Russia responded to Ukraine's requests, it offered no real help. For example, Ukraine sought assistance regarding the supply of weapons to DPR fighters by O. Kulugina, a Russian citizen. Ukraine asked Russia for information on Kulugina's crossings of the Ukraine-Russia border. Rather than offer the greatest measure of assistance, the Russian prosecutor's office took it upon themselves to conclude that Ukraine didn't need this assistance because it was supposedly, quote, irrelevant to the subject matter of the pretrial investigation being conducted by Ukraine. Yet Ukraine was investigating allegations of crossing the Ukraine-Russian border with weapons. It's difficult to see how information about Ms. Kulugina's border crossings and illegal weapons possession would not be relevant to that crime. Far from offering Ukraine the greatest measure of assistance under Article 12, Russia offered Ukraine no assistance at all. Let me conclude by focusing on ICSFT Article 18. Article 18 is essential to achieving the Convention's purpose. Article 18 requires states parties to cooperate in the prevention of terrorism financing by taking all practicable measures to prevent and counter preparations for the offenses set forth in Article 2 of the Convention. As Professor Koh explained, Russia reads this provision as a nullity under which Russia has no obligation to do anything but have a terrorism law on paper. What Article 18 really requires is what the text says. States must take all practicable measures to prevent and counter preparations for terrorism financing. Today, you have heard extensive evidence of terrorism financing offenses. Russian persons delivered weapons, money, and other support to groups well known for committing acts covered by Articles 21A and 21B of the ICSFT. In many cases, the specific weapons Russian officials provided were immediately used to commit more terrorist acts. Russian politicians, non-governmental organizations, and private persons openly raised money and collected equipment for groups that notoriously committed terrorist acts. These were Article 2 offenses, and Russia had an obligation to take all practicable measures to stop the financing of them. Instead, Russia did nothing. Russia could have prevented terrorism financing by policing its border. As Mr. Zients mentioned earlier, Ukraine specifically asked Russia to do this. UN monitors warned of the devastating consequences to the human rights of civilians resulting from the flow of weapons across an uncontrolled border. Yet again, Russia refused to take the most obvious practicable measure of policing it. Russia also could have instructed its own officials not to send weapons and money to groups committing terrorist acts in Ukraine. that would have been simple, practicable, and capable of preventing terrorism financing. Russia refused to take that step. Russia also could have shut down the fundraising networks used to support the groups committing terrorist acts in Ukraine. This fundraising was happening in the open, through public social media channels and websites, and it was practicable for Russia to stop it. Again, Russia did nothing. Article 18 does not speak of sitting idly by, feigning an inability to assist, and hiding behind unspecified procedural or other formalities to do nothing. It speaks of taking all practicable measures to prevent and counter the commission of terrorism financing offenses. Russia chose to take no measures at all. Russia chose to do nothing, and in doing so, it violated Article 18. The preamble of the ICSFT considers, quote, that the financing of terrorism is a matter of grave concern to the international community as a whole. Today, you have heard that the financing of terrorist acts in Ukraine by Russian persons was of no concern to Russia, and Russia did nothing to fulfill its obligations under the ICSFT to investigate, to afford the greatest measure of assistance, and to take all practicable measures to counter terrorism financing. In other words, Ukraine has proven multiple violations of the ICSFT by the Russian Federation. Madam President, members of the court, I thank you for your attention, and this concludes Ukraine's pleadings regarding the ICSFT. I would now ask that you call upon Professor Ko to speak to Ukraine's claims under the Convention for the Elimination of All Forms of Racial Discrimination.
I thank Ms. Cheek, and I now call on Professor Harold Ko to address the court. You have the floor, Professor.
Madam President, members of the court, it's again my honor to appear before you on behalf of Ukraine. This afternoon, I will introduce Ukraine's case concerning Russia's numerous violations of the Convention for the Elimination of All Forms of Racial Discrimination, the CERD. The origins of that treaty are well known to you. The CERD emerged in response to toxic patterns of colonialism, the Holocaust, apartheid, and racist practices that have plagued our collective history. In response, the international community developed universal human rights standards to recognize the equality of all peoples. The CERD was adopted in 1965 as the first of several universal human rights treaties elaborating upon these principles. When the General Assembly adopted the convention that year, the UN Secretary General called it a most valuable instrument to empower the United Nations to carry forward its efforts to eradicate the vestiges of racial discrimination. The treaty's text reflects the states parties' resolve to adopt all necessary measures for speedily eliminating racial discrimination in all its forms and manifestations. To that end, the CERD establishes an absolute prohibition against racial discrimination, defined as any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. As this court knows too well, this is one of the most fundamental protections in human rights law. For that reason, the total prohibition against racial discrimination contained in the CERD is both an erga omnes obligation of states and a peremptory norm of customary international law. jus cogens. Because the CERD's prohibition of racial discrimination is absolute, no derogation from it is permitted. The CERD contains no exceptions to the prohibition on racial discrimination. Other human rights treaties have affirmed its non-derogable nature, and any effort to limit human rights nevertheless requires adherence to this fundamental norm of non-discrimination. The Convention's absolute guarantees require all contracting states to suppress racial discrimination in all its forms. Yet by its discriminatory treatment of the Crimean Tatar and Ukrainian communities in Crimea, Russia has utterly failed to meet its affirmative obligations under the CERD. Even worse, Russia has sought to replace the multi-ethnic community that had characterized Crimea before Russia's intervention with discriminatory Russian nationalism, described in the report of Russia's expert Sergei Markidanov as the artificial separation of Russians and Ukrainians. So through concerted cultural erasure, Russia has established a policy and practice of racial discrimination that is the exact opposite of what the CERD requires. Russia's campaign of racial discrimination grew out of its illegal military occupation and purported annexation of the Crimean Peninsula starting in February 2014. When Russia unlawfully invaded and occupied Crimea, it identified the Crimean Tatar and ethnic Ukrainian communities as obstacles to its twin aims, annexation and regional domination. From the first days of Russia's military intervention in Crimea, representatives of the Crimean Tatar and Ukrainian communities quickly mobilized to oppose Russia's actions. Even as Russia's military intervention in Crimea was underway, the Mejlis organized a rally in front of the Crimean Parliament building in Simferopol to oppose Crimea's accession to the Russian Federation. The members of that body invited representatives of the local Ukrainian community to join them in protest. But as demonstrators gathered in the square, gangs of young men carrying Russian flags formed against them. And as the day unfolded, the two sides sought to push each other's supporters out of the Parliament building. In the crush, 2 people died, some 70 others were injured. And this image of Ukrainian and Crimean Tatar flags opposing Russian flags explains why the Russian authorities felt the need to punish those ethnic groups as groups. From the start of the purported annexation, Russia pitted ethnic community against ethnic community. The next day, heavily armed men in uniforms without insignia seized the Crimean Parliament building and raised the Russian flag. An occupied so-called parliament then convened an extraordinary closed session and dismissed the existing government. This sham body then appointed as Prime Minister Sergei Aksyonov, the pro-Russian leader of the radical Russian Unity Party, even though his party held only 3 out of 100 seats in the Crimean Party. These Russian proxies then moved to convene a sham referendum on Russia's invasion of Crimea. As the sham referendum approached, the Russian Federation tried and failed to induce the Crimean Tatar and Ukrainian communities to support the purported annexation. Our evidence presents the testimony of Mr. Mustafa Jamilev, the first chair of the Mejlis and a pioneering figure in the Crimean Tatar community. He testifies regarding a telephone call he had directly with President Vladimir Putin on 12 March 2014, engineered by the Russians. And during that conversation, President Putin sought the Crimean Tatars community's support for union with Russia in return for unspecified favorable treatment in the future. But Mr. Zhemilev rebuffed that request and continued to insist Crimea was part of Ukraine. The Russians conveyed a similar message to Metropolitan Clement, who is in the courtroom today. He is the head of the Orthodox Church of Ukraine, which at that time was the Crimean Eparchy of the Ukrainian Orthodox Church of Kiev Patriarchate. Father Clement describes meeting with Igor Strelkov, also known as Igor Girkin, who introduced himself as an advisor on security and defense to the Council of Ministers of the Republic of Crimea. This morning from Mr. Zions, we heard about Girkin, the notorious GRU member who later became a leader of the DPR in connection with the shootdown of MH17. Girkin informed Father Clement that, quote, he would be safe and his church would be protected if he agreed to sign a document to be published in press, confirming that in Crimea everything was calm and quiet and no illegal actions were taken against Kiev Patriarchate. Father Clement declined to sign the statement because, he testified, it falsely suggested his support for the purported annexation in its final form. Even as Russia was vainly seeking political support from the Crimean Tatar and Ukrainian communities, pro-Russian forces were creating a hostile and intimidating environment for these same groups. The doors and gates of Crimean Tatar houses were marked with crosses, a chilling reminder of the infamous historical episode known to Crimean Tatars as the Surgun, when Soviet authorities similarly rounded up Crimean Tatars for deportation and forced their exile based on the false pretext that they had collaborated with the Nazis during World War II. And at the same time, unidentified, uniformed armed men, little green men, began appearing in Crimean Tatar settlements claiming to own Crimean Tatar properties. As you'll soon hear in more detail, Crimean Tatar and Ukrainian activists became targets of brutal disappearances, murders, and torture. An early tragic victim was Reshat Amatov, a well-known activist in Crimean Tatar, who was kidnapped by uniformed men while silently protesting in front of the Cabinet of Ministers building in Simferopol. Mr. Amatov's body, bearing signs of brutal torture, was found 2 weeks later. The Russian Federation and its agents also sought to stir up fear and hatred by the ethnic Russian majority against the Ukrainian community through a vigorous disinformation campaign, which claimed that fascists had seized power in Kyiv and intended to come to Crimea to punish ethnic Russians there. Posts appeared across social media, claiming that Crimea was under threat from Nazis, a chilling preview of a broader disinformation campaign that Russia continues today, employing it against Ukraine to support its brutal invasion based on false claims of preventing genocide. In the divisive run-up to the sham referendum, as this outrageous campaign poster shows, the forthcoming vote was depicted as 16 March, we choose between, on the left, Ukrainian Nazis, or on the right, Russia in Crimea. Yet despite all of this intimidation, on 16 March 2014, the vast majority of the Crimean Tatar community, and reportedly nearly 500,000 ethnic Ukrainians, boycotted the sham referendum. Yet in reporting the results, pro-Russian Crimean authorities falsely claimed that more than 90% of the voters, on a turnout of 83.1%, had voted in favor of Crimea's union with Russia. Madam President, members of the court, it is thus no mystery why the courageous Crimean Tatar and Ukrainian opposition to Russia's brutal actions would lead an authoritarian regime, intolerant of any opposition, to deliberately target these ethnic communities for discriminatory treatment. As Ukraine demonstrates in its pleadings, the Russian Federation engaged in a two-part campaign to assert its dominance in Crimea by culturally erasing the Crimean Tatar and Ukrainian communities. First, Russia forcefully brought the full weight of its authoritarian security machinery into Crimea and applied it selectively to destroy the political and human rights of the Crimean Tatar and Ukrainian communities. Second, Russia abused its position as occupying power to promote its own culture, even while suppressing every means available to the Crimean Tatar and Ukrainian communities to preserve their own identities through cultural gatherings, mass media, education, or otherwise. The aim of both kinds of Russian action was unambiguous: racial discrimination. Their illegal purpose and effect violates the SURD's absolute prohibition against racial discrimination. Yet instead of explaining how its conduct in Crimea can be reconciled with its SURD obligations, Russia's response throughout these proceedings has instead been deflection and evasion. To evade accountability for its blatant violations of the SURD, Russia has erected a paper castle of unsupported legal arguments. But on examination, these empty arguments collapse, and the illegality of its actions cannot be denied. Instead of acting to suppress racial discrimination, as the SURD requires, Russia has shown its contempt for the Convention and the fundamental rights it safeguards by its ongoing treatment of these two groups protected by the SURD in Crimea, the Crimean Tatars and ethnic Ukrainians in Crimea. Russia's obvious disdain for equality rights is further confirmed by its refusal meaningfully to engage with the SURD Committee on issues related to Crimea, Sevastopol, and the ongoing armed conflict. Madam President, members of the Court, as you observed in your preliminary objections judgment in this case, quote, both parties agree that Crimean Tatars and ethnic Ukrainians in Crimea constitute ethnic groups protected under SURD. The existence of these two ethnic groups is firmly rooted in objective historical fact, confirmed by how both groups now choose to self-identify. The history of the Crimean Tatar community dates back centuries. It comprises individuals who describe themselves as such, who are Muslims of the Sunni faith, and who may but do not necessarily speak or understand a Turkic language called Crimean Tatar. As Professor Magosi explains in his expert report, central to the Crimean Tatar sense of identity has been the cultivation of historical memory, including through commemoration of historical figures and events. The Crimean Tatar community vividly recalls having spent nearly half a century in exile, thousands of miles from their ancestral home, after being brutally deported to Soviet Central Asia by then Soviet dictator Joseph Stalin at the end of the Second World War. Yet tragically, Stalin's racially discriminatory decision to impose brutal collective punishment on the Crimean Tatars as a group has now been replicated today by the current Russian regime's decision to brutally target their civil and cultural rights. By comparison, the ethnic Ukrainian community in Crimea has a more recent history. It encompasses those who speak Ukrainian as their primary means of communication, those who follow Ukrainian cultural traditions, as well as Russian speakers who self-identify as Ukrainian. The evidence shows that the Russian Federation has singled out both of these communities, Crimean Tatars and ethnic Ukrainians, as distinct ethnic groups who they subject to differential and discriminatory treatment. So by its discrimination, Russia confirms that these ethnic groups exist. Ukraine's expert, Professor Fredman, has explained, quote, where identification of an ethnic group is imposed by the dominant population in order to remove rights, or where a group is identified by the dominant population in a country as ethnically different, this will be recognized. The third committee has also suggested that a group may be identified by the dominant population in a country as ethnically different, even if it does not regard itself as such. And international criminal tribunals, such as the Rwanda Tribunal, have similarly observed that, among other considerations, identity could be created and entrenched by an external dominant group, such as a colonial force. But despite the parties' agreement that Crimean Tatars and ethnic Ukrainians constitute protected groups under the Third, Russia's lawyers would reduce Ukraine's definition of ethnicity to the simplistic claim that political views can define ethnicity. Russia argues that Ukraine seeks wrongly to broaden the notion of racial discrimination under the Third by defining the Ukrainian community in Crimea as an ethnic group in light of political views or opposition. So Russia claims that Ukraine's definition of ethnicity is just a litigation tactic to further its real goal to challenge the status of Crimea. For at least 4 reasons, this court should not be sidetracked by Russia's misdirection. First, as already noted, Russia itself has admitted to the existence of a Crimean Tatar and ethnic Ukrainian community in Crimea. It has identified no specific claim or issue by Ukraine that turns on any claimed difference between the parties regarding the definition of ethnicity. Second, Russia's argument is based on a gross mischaracterization of Ukraine's position. Ukraine's claim is not that a person's ethnicity depends on political opinion. Rather, Ukraine has explained that the political community, and therefore the collectivity of other citizens with whom he or she most identifies, is a relevant factor in assigning ethnicity. It's no surprise that common ethnic identity will breed political community. History shows that ethnic groups usually desire to live together within a common political state. As Professor Magosi has explained, this has been a goal of the Ukrainian nationalist movement since the 19th century, and especially since Ukraine's independence in 1991. Identification with the Ukrainian state has become an increasingly important marker of Ukrainian self-identity. This is particularly true among younger Ukrainians who have grown up exclusively within a free and democratic Ukraine. These are the people who are fighting for Ukraine now. For many Ukrainians in Crimea, it's obvious why, especially after Russia's invasion in February 2014 and its even more brutal invasion of the entire territory of Ukraine 9 years later, that their self-identification as Ukrainians, not Russian, would only intensify. Third, Russia argues for an outdated, static view of ethnicity, relying on this court's quite different judgment in Qatar versus UAE. But as the court recalls, that case was not about ethnic origin. It concerned whether the Third's protection based on national origin extends to measures based on national citizenship. This court was thus called upon to interpret the meaning of the term national origin as that phrase is used in the Third. But on its face, the concept of national origin is plainly distinct from the term at issue here, ethnic origin. This distinction is also reflected in the Convention's drafting history. And so the court in Qatar versus UAE considered issues that specifically concern national origin, such as the Third's express exclusion of measures based on citizenship reflected in Articles 1.2 and 1.3, as well as evidence from the Convention's drafting history. The court held the term national origin does not encompass current nationality. But in this case, unlike the Qatar case, is about discrimination based solely on ethnic origin, directed against affected communities who are undeniably protected ethnic groups under the CERD. And fourth, Russia charges that Ukraine's definition of ethnicity demonstrates that its real goal is to challenge the status of Crimea. But this is only further evidence of Russia's effort to make this case something it is not. As this court has already acknowledged, Ukraine does not ask this court to make any determination regarding the status of Crimea. Ukraine seeks only to hold Russia accountable for its naked violations of the CERD. Russia's baseless claim simply ignores this court's own clear statement at preliminary objections that in the present case, the court notes that Ukraine is not requesting that it rule on issues concerning the Russian Federation's purported aggression or its alleged unlawful occupation of Ukrainian territory, nor is the applicant seeking a pronouncement from the court on the status of Crimea or on any violations of the rules of international law other than those contained in the ICSFT and CERD. These matters, therefore, do not constitute the subject matter of the dispute before the court. It could not be any clearer. So in sum, Russia cannot hide behind its purported annexation of Crimea to evade accountability for its violations of the CERD. So the question before you is discrimination, pure and simple. Has Russia discriminated against the Crimean Tatar and ethnic Ukrainian communities in the peninsula in purpose or effect? But instead of answering that straightforward question, Russia tries to justify its discrimination, such as its ban on the Mejlis, the detentions and searches of certain individuals, and the limitations imposed on the organization of certain public rallies and protests. Russia would have you excuse that discrimination based on national security, anti-extremism, and public order. But these excuses have no traction here, for the simple reason that the CERD's absolute prohibition of racial discrimination is not subject to derogation. Russia cannot claim exemption from its non-derogable CERD obligations just because it has adopted measures ostensibly directed at national security or extremist threat or a risk to public order. Russia would treat national security, anti-extremism, and public order as self-judging exceptions to its peremptory human rights obligations that it is free to invoke retroactively and at will. Although national security is recognized in international human rights law as a legitimate aim that may, under different circumstances, justify necessary and proportionate restrictions on other non-peremptory rights, it cannot provide proper justification in respect of any intrusions into so-called underlying substantive rights. Nor does international law support countering extremism as a legitimate objective that could justify restrictions on appropriate human rights. Because national anti-extremism laws do not enjoy global acceptance, they require even closer scrutiny than counterterrorism laws. But Russia would justify its actions by citing its own domestic statutes or case laws. But it is those very Russian laws and their racially discriminatory application in Crimea that violate the CERD. Russia's anti-extremism laws in particular have granted Russian authorities arbitrary powers that they have widely abused to suppress the Crimean Tatar and ethnic communities. For that reason, those laws have been widely criticized. To take just one example, in 2017, the CERD Committee identified Russia's anti-extremism law, federal law number 114FZ, as vague and broad, an issue exacerbated by Russia's amendments to its criminal code. The CERD committee expressed concern that these laws contained no precise and clear criteria on how materials may be classified as extremist. The sweeping definitions in this law, the committee observed, can be used arbitrarily to silence individuals, in particular those belonging to groups vulnerable to discrimination, such as ethnic minorities, indigenous peoples, or non-citizens. Other international organizations, including notably the Human Rights Committee of the ICCPR and the Venice Commission, have echoed the CERD committee's concerns. The European Court of Human Rights has also dealt with many cases in which it has found Russia's application of this Russian federal law in violation of international standards. Yet Russia's rejoinder entirely fails to undermine the weight of this international authority. Shortly before Russia purported to annex Crimea, Russia amended its criminal code to criminalize, quote, public calls to carry out actions aimed at violating the territorial integrity of the Russian Federation. Upon supposedly annexing the peninsula, Russia extended to Crimea the application of both its anti-extremism statute and its amended criminal code. These amendments only exacerbated the discriminatory impact of Russian federal law. And by so doing, Professor Martin Scheinin has observed, Russia effectively made it a crime to publicly state the simple fact that Crimea is part of the internationally recognized territory of Ukraine. Consequently, based on his expert review of Russia's anti-extremism laws, Professor Scheinin, the first UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, concluded that these laws, quote, should not enjoy the benefit of being treated as a neutral legal framework which is being applied in good faith to the benefit of good order. Instead, he said, these laws should be regarded as suspect because their inherent features make them into a mechanism for targeting not only dangerous and violent actions, but also any mobilization or activity of ethnic communities that could be perceived to indicate disloyalty to the central government. Thus, far from justifying Russia's discriminatory treatment of the Crimean Tatar and ethnic Ukrainian communities, Russia's extremism laws are evidence of Russia's discriminatory purpose in harshly applying its laws against those communities. Russia's anti-extremist framework and its other efforts to address anti-terrorism, national security concerns, or issues of public order are thinly disguised tools to punish those ethnic communities who refuse to declare fealty to the Russian government. So at bottom, these laws are not for the purpose of national security or anti-extremism. Russia's application of these laws in Crimea has a deliberate discriminatory purpose and a devastating discriminatory effect. Because the Russian legislation and measures at issue amount to racial discrimination, this court must conclude that the CERD is violated. Russia cannot invoke allegedly legitimate aims to justify measures that choose to discriminate based on race or ethnic origin. The convention itself makes clear, even lawful ends can never justify discriminatory means. As this afternoon proceeds, we will demonstrate how the purpose and effect of Russia's measures has been to discriminate against Crimean Tatar and ethnic Ukrainians, and further show why Russia cannot escape liability by claiming such justifications as national security. Ms. Cheek will return to the podium to explain next why, as a matter of law, a state may only assert such justifications in a narrow class of cases where it must satisfy a high evidentiary burden that Russia does not remotely meet. Then my colleague, Ms. Trevino, will document, as a matter of fact, the discriminatory purpose and effect of Russia's myriad discriminatory acts in Crimea, restricting civil and political rights and erasing cultural expression. Finally, Professor Tuvinen will close our presentation by showing how Russia's overtly discriminatory campaign in Crimea has violated your provisional measures order in this case, and against your clear mandate, clearly and gravely aggravated this dispute. To repeat what I said this morning, the court's recent decision in the certain Iranian assets case specified that the unclean hands doctrine is not part of customary international law or a general principle of law. The court further recognized that as a defense on the merits, the court has always treated the invocation of unclean hands with the utmost caution. Russia's exorbitant unclean hands claim here again shows why this utmost caution is warranted. Just as Russia did to advance the same argument to evade its responsibility under the ICSFT, it is making similar outlandish claims against Ukraine, baselessly branding Ukrainian and Ukrainian government as Nazis who are oppressing Russian speakers. But Russia supports its claim with no evidence because there is none. Russia simply repeats its own government propaganda, outrageously mischaracterizing both objective facts and applicable Ukrainian laws. Madam President, members of the court, Russia's efforts are particularly egregious in a case like this, where the treaty involved is a landmark, erga omnes human rights instrument, and where Russia has engaged in systematic campaign of racial discrimination that violates almost every provision of this historic treaty. Russia would distract you from its own egregious misconduct by claiming that Ukraine is mistreating ethnic minorities in its territory, including Crimean Tatars. Crimean Tatars who had been forcibly deported from Crimea under Stalin returned to an independent Ukraine, encouraged by Ukrainian authorities. Before Russia's purported annexation, Ukraine worked hard to build a genuinely multi-ethnic society of Ukrainian, Russians, and Crimean Tatars, as well as other groups in Crimea. Ukraine has acknowledged the challenges that it has faced in reintegrating hundreds of thousands of returning Crimean Tatars into the economy and society of the peninsula. But Ukraine has also demonstrated that, unlike Russia, it made conscious, substantial efforts to promote multiculturalism in Crimea. So just before the purported annexation in 2013, the High Commissioner for National Minorities of the OSCE praised the Ukrainian government for its efforts to reintegrate the Crimean Tatar and other formerly deported peoples, while noting that much work remained to be done. And these efforts continue today, as reflected in the Law on Indigenous Peoples of Ukraine, adopted in July 2021. But crucially, this case is not about Ukraine's treatment of any of these minorities. This case challenges Russia's many acts of discrimination in violation of the CERD with respect to the Crimean, Tatar, and Ukrainian communities. For all of its rhetoric, Russia has conspicuously declined to raise any counterclaims challenging Ukraine's liability under the convention. Russia's glaring omission makes its renewed unclean hands argument not just demonstrably false, but just legally irrelevant to the case before you. Madam President, members of the court, every day we witness Russia's contempt for the human rights of the Ukrainian people. But the point is this: Russia does not just bomb and shell. It does not just tolerate and support those who terrorize the Ukrainian people. It is pursuing a long-term project to erase the rights and culture that make Ukraine a proud multi-ethnic nation, to wipe out what makes Ukrainians, Ukrainians, and what makes Crimean Tatars, Crimean Tatars. And now, Russia would seek to enlist this court to condone this blatantly discriminatory campaign. But after so many years, the path is finally clear. you can finally rule on the merits that Russia's acts violate this historic convention for the elimination of all forms of racial discrimination. The law is clear. The evidence is overwhelming. We ask you to give judgment for Ukraine and thereby to send a message to all nations by rejecting Russia's transparent attempt to avoid accountability for its discrimination in Crimea. I now ask that you call to the podium Ms. Cheek.
I thank Professor Coe, and I now give the floor again to Ms. Marnie Cheek. You have the floor, Ms. Cheek. Please go ahead.
Madam President, members of the court, it's an honor to appear again before you in these proceedings on behalf of Ukraine. The focus of my presentation will be the legal obligations of the Russian Federation under the Convention for the Elimination of All Forms of Racial Discrimination. First, I will address the definition of racial discrimination reflected in Article 1.1 of the Convention. In this context, I will clarify that Ukraine's claims are those of race discrimination, not political discrimination. I also will address Russia's mistaken argument that its forced citizenship regime is beyond the CERD's purview. Second, I will focus on Russia's legal violations of the CERD, which will then be addressed in more detail by my colleague, Ms. Clovis Trevino. Finally, I will discuss the appropriate standard of proof in this case. I will explain why this court must reject Russia's attempt to make racial discrimination under the CERD more difficult to prove, just because Russia has aggressively engaged not only in individual, isolated instances of discrimination, but in a pattern of discriminatory conduct. Let me first turn to the Convention's definition of racial discrimination. As you are aware, the Convention defines racial discrimination broadly. The first element of the definition is, quote, a distinction, exclusion, restriction, or preference. The plain meaning of this language reflects the CERD's broad prohibition on all forms of racial discrimination. The drafting history of the Convention further confirms the intended breadth of this language. As noted by Finland's representative in the early stages of the Convention's drafting, quote, the words distinction, exclusion, preference, and limitation would cover all aspects of discrimination which should be taken into account. The word limitation was ultimately replaced by restriction, but this amendment does not detract from the point. By the time the Third Committee came to a vote on what would become the final text of Article 1.1, the drafter's intention was clear. In the words of the U.S. delegate, quote, every form of racial discrimination was pernicious, and the Convention's definition in Article 1 applied to every manifestation of that evil, even if each one was not specifically mentioned. The second element of the definition of race discrimination requires that the relevant distinction, exclusion, restriction, or preference be based on a protected ground, namely race, color, descent, or national or ethnic origin. It's well understood that Ukraine's claims focus on discrimination as to ethnic origin against the Crimean Tatars and the ethnic Ukrainians in Crimea. Discrimination based on a protected ground is a broad concept. As Judge Crawford explained in his declaration at the provisional measures phase of this case, Article 1, quote, does not require that the restriction in question be based expressly on racial or other grounds enumerated in the definition. It is enough that it directly implicates such a group on one or more of these grounds. The breadth of the term based on is confirmed by the context in which it appears in Article 1.1. As the third committee explained in its general recommendation number 14, quote, "The words based on do not bear any meaning different from on the grounds of, such that a distinction is contrary to the convention if it has either the purpose or effect of impairing particular rights and freedoms." This leads me to the third element of the Article 1.1 definition of racial discrimination, the phrase purpose or effect. The disjunctive "or" in the phrase purpose or effect makes clear that the third protects against both discrimination that can be demonstrated to have a discriminatory purpose, as well as effects-based discrimination, where a measure is facially neutral but gives rise to a distinction, exclusion, restriction, or preference in the form of an impermissibly disproportionate impact on a protected class. Whether discriminatory in purpose or effect, the prohibition against racial discrimination is absolute. Put another way, once racial discrimination has been established, there is no circumstance under which a derogation is allowed, as Professor Coe explained earlier. In examining what constitutes racial discrimination under the CERD, the parties have divergent views of how to meet the definition of racial discrimination in Article 1.1 and what evidence is required. Of course, in the modern era, there are few laws that simply state a racist purpose or mandate a racist effect. And so it's appropriate, indeed it's necessary, to look to circumstantial evidence to determine whether racial discrimination has occurred. First, let me speak to purpose. Discriminatory purpose may be apparent on the face of a challenged measure, but discriminatory purpose also can be ascertained from the nature or context of the measure. With regard to the Russian Federation's actions in Crimea, Russia has singled out ethnic minorities for discriminatory treatment, including through the enforcement of broad and vague laws engaging in a pattern of conduct that evidences racial animus and discriminatory purpose. As I mentioned, once discriminatory purpose is established, the definition of racial discrimination under Article 1.1 of the CERD is met. Second, let me speak to effect. The context and circumstances of a challenged measure are also relevant to the assessment of effects-based discrimination. As the CERD Committee observed in LR versus Slovakia, in assessing measures which are discriminatory in fact and effect, the committee must take full account of the particular context and circumstances of the petition, as by definition, indirect discrimination can only be demonstrated circumstantially. While the Convention speaks of purpose or effect, at times the two should be read together in assessing racial discrimination. As Judge Theodore Marone has observed, quote, "The word effect may thus bring actions for which discriminatory purpose could not be established within the scope of the Convention, by allowing the inference of purpose from effect, where a measure is by allowing the inference of purpose from effect, consequences may be probative of an actor's intent." In other words, where a measure is discriminatory in effect, this may also be evidence that discrimination was the purpose of the measure all along. The Russian Federation claims, and I quote from its rejoinder, that where, quote, "a given measure can be reasonably justified or deemed legitimate, it does not qualify as racial discrimination under the CERD. But reasonably justified is not the applicable standard. As the CERD Committee has stated in its General Recommendation number 14, in seeking to determine whether an action has an effect contrary to the Convention, it will look to see whether the challenged measure has an unjustifiable disparate impact on a protected group. Further, any disparate impact on the basis of a protected ground must be based on a legitimate justification when judged against the objectives and purposes of the Convention. In the context of the ICCPR, for example, the Human Rights Committee has set out a rigorous test. This intrusive measure is, among other things, necessary, has a genuine and identifiable legitimate aim, and conforms to the strict principle of proportionality, and that the expected benefit obtained towards serving a legitimate aim invoked outweighs any adverse impact on human rights. It follows that conduct resulting in a disparate impact will constitute racial discrimination unless the relevant measure is necessary, it has a legitimate aim, and is proportionate, and that the expected benefit in furtherance of the legitimate aim outweighs any adverse impact on human rights. This is an objective assessment that precludes Russia from invoking its self-judging justifications or hiding behind its national laws to racially discriminate. Clear and objective proof is required, and the standard is high. Russia has come nowhere close to satisfying this high bar for justifying effects-based discrimination. The Court also should bear in mind that the adverse impact on human rights is comprehensive in scope, covering, in the words of Article 1.1, any acts, quote, nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of human life. This is the comprehensive legal framework that it should inform the Court's analysis of Ukraine's claims. I turn next to the question of whether conduct that constitutes racial discrimination in purpose or effect nonetheless falls outside the scope of the Convention merely because that conduct may have been motivated by political reasons. The answer to this question is no. The Russian Federation subjected the Crimean Tatar and Ukrainian communities in Crimea to unfavorable treatment as a collective punishment for opposing Russia's unlawful